None of the behaviors nor verbal remarks at the time of the arrest suggest he was behaviorally dysregulated or that his reality contact was impaired. Following his arrest and being taken into custody, he engaged in an informal series of verbal exchanges with authorities, and none of his statements taken at face value suggest he was then actively psychotic or that his behavior controls were substantially impaired. She then goes on to talk about the Mirandized statements. This court personally watched every minute of that interaction with Detective Carpenter and Detective Stern, along with the one from the night before, which was at the hospital within hours. And I would concur with the examiner's conclusions that the content of his initial statements to authorities included multiple efforts to deceive or mislead. He changed his story multiple times, including he initially denied being in Waukesha the prior Saturday. He initially asserted he traveled to Waukesha on the day in question in a tan Kia with a friend. He initially asserted his mother did not own a vehicle, though later acknowledged as much, and that he used it from time to time. Other changes in his story over the course of his statements and the nature of them further suggest that he was making active attempts to evade detection or responsibility. By implication, such behavior strongly suggests that his reality contact was then intact. When he was shown photographs of driving in the SUV into the parade route, he indicated it was not him. And this is again the examiner. With the police. She's noting the police contact. It was not until Mr. Brooks was in the booking area of the Waukesha County Jail that he displayed some emotion, and this was to, I believe, Detective Stern, where he said, "I didn't mean to kill nobody." Such a remark indicates an awareness of the consequences of his actions and runs counter to a conclusion of an exculpatory mental disease or defect. There's other criteria or other factors. I'm not going to read them all. That was probably one of the more comprehensive explanations of why that examiner did not conclude that there was support for the special plea of not guilty by reason of mental disease or defect. All four examiners shared similar observations. Certainly their conclusions were that there was not support for the special plea. One examiner talked about, again, conduct after driving through the parade, abandoning the vehicle used in the act, altering his appearance by removing his outer layer of clothing, altering how he was wearing his hair, and then engaging in further efforts to leave the scene by securing transportation via a ride-sharing application. This particular examiner went on to say, while he essentially, meaning Mr. Brooks, disclaimed any memory of those actions and could therefore not explain them, such behaviors strongly suggest an awareness of wrongdoing and a desire to avoid detection. Another examiner had very similar things: antisocial personality disorder with border.
If you own a gun for self-defense, this free guide is a must to avoid risking your freedom. Hi, I'm Master Ken.
Another examiner had very similar things: antisocial personality disorder with borderline features, talked about the cannabis use disorder and full remission in a controlled environment. What's interesting about this particular report is the description of an antisocial personality disorder. The DSM-5 defines antisocial personality disorder as a pervasive pattern of disregard for a violation of the rights of others occurring since age 15 years, as indicated by three or more of the following: failure to conform to social norms with respect to lawful behaviors, as indicated by repeated performing acts that are grounds for arrest. 2, deceitfulness, as indicated by repeated lying, use of aliases, or conning others for personal profit or pleasure. 3, 3, impulsivity or failure to plan ahead. 4, irritability and aggressiveness as indicated by repeated physical fights or assaults. 5, reckless disregard for safety of self and others. 6, consistent irresponsibility as indicated by repeated failure to sustain consistent work behavior or honor financial obligations. 7, lack of remorse as indicated by being indifferent to or rationalizing having hurt, mistreated, or stolen from another. In addition, the individual is at least 18 years old and there is evidence of a conduct disorder prior to the age of 15. This examiner noted Mr. Brooks meets nearly all of the symptoms described above because he has exhibited a long-term maladaptive pattern of behavior involving a disregard for and violation of the rights of others, beginning in childhood and continuing through adult life. The borderline features reflect a general inability to sustain healthy relationships with others, including his domestically violent relationship with victim PPP. That examiner goes on with further analysis and conclusions, again finding that there is not support. The last examiner, again, made similar conclusions, also diagnosing Mr. Brooks with an antisocial personality disorder. Why is that important? There is no doubt that in our criminal justice system today, we face a crisis of the mentally ill intersecting in our courts. In the last year and a half alone, this court has ordered many competency evaluations, presided over a number of contested competency hearings, and ordered many evaluations for the special plea of not guilty by reason of mental disease or defect. And the bottom line is, for this court, Mr. Brooks does not present as a person who is either not competent or not guilty by reason of mental disease or defect. It is frankly heartbreaking to see those individuals who truly suffer from schizophrenia, for example, intersect in our criminal justice system. Sometimes they do unspeakable things. They hurt other people. I'm thinking of one such gentleman who was so schizophrenic and out of control. He couldn't even be kept in the courtroom. He was too loud. He clearly, if you've ever been in the room with someone who is suffering from auditory or visual hallucinations, it is not something you easily forget. It makes an impression, even on someone like myself who's not an MD or a doctorate level psychologist. I've been in the room with an individual who was, when I did defense work, and he was accused of killing someone near and dear to him. It's a very different presentation. It's heartbreaking. It's heart-wrenching. Do the mentally ill sometimes commit atrocious crimes? They do. This is not one of those situations. We've heard Mr. Brooks's family talk about mental illness and bipolar. You know, in addition, before I get to that, I've also had, over my 11 years on the bench, of coming face to face with evil on occasion. There are many times, good people do bad things, but there are times when evil people do bad things. There is no medication or treatment for a heart that is bent on evil. Child trauma, bipolar, indifference, physical abuse of a child, or even childhood trauma did not cause Darrell Brooks to commit the acts for which he will be sentenced here today. It is very clear to this court that he understands the difference between right and wrong, and that he simply chooses to ignore his conscience. He is fueled by anger and rage. Some people, unfortunately, choose a path of evil. And I think, Mr. Brooks, you are one of those such persons. As a mom, my heart breaks for your family, for your mom, and for your grandmother. The son that she raised, the grandson that your grandmother knew, the hopes and dreams they had for your life, they're gone. And I think it's perhaps far easier for them to blame a mental illness than to perhaps come to grips with their son did very, very bad things due to very bad motivations. One of the things ultimately that will happen when you are in prison, sir, is that the Department of Corrections, they are statutorily responsible for your care and your well-being, including your mental health. I do not have any authority to dictate to them where you go or how they treat you. That is far different than when there is support for a plea of not guilty by reason of mental disease or defect, because then the court has available what is called treatment facilities and a commitment to such a treatment facility. That is something that is simply not on the table. And again, 4 evaluations, not even my own assessment, but 4 evaluations from licensed professionals say otherwise. Even in the face of your family saying that, and even in the face of you claiming that. I'm not even here to say that some of those things can't coexist, and you might not have some of your own mental health issues, whether it be bipolar, childhood trauma, or things of that nature. But the bottom line is none of that caused you to do what you did on November 21 of 2021. I want to next turn to the trial in this case. I think it's important that the sentence here today focuses on your conduct on November 21 of 2021 and the moments leading up to that tragic and fateful decision of yours to drive through the Waukesha Christmas Parade, and of course the moments after.
Are you sick of living with filthy, blood-sucking bedbugs biting you all night long? Well, there's finally a quick and easy...
I, of course, through my sentencing remarks and ultimately what I do here today, I can't answer all of the questions. I can't address all of the issues, including the why. Perhaps the one question that will remain unanswered. Why? Why did you barrel down White Rock Avenue? Why did you not stop? Why did you keep going? Many of us in this courtroom sat through the entire trial. And what we learned is that very early on in the afternoon of November 21, starting at around 1 p.m., the police got ready for the parade. The staging area was set up, and that was all along White Rock Avenue. Signs were put in place. Ultimately, barricades were put up at a number of locations on Main Street and surrounding that. We know, because we heard from Sergeant Warner about what he had done, and he had, right before the start of the parade, had driven down the parade route. It was on his shoulders, his responsibility to make sure everything was safe and in order. What's important about that staging area, sir, is we know that that is where the altercation with Erica Patterson really came to a head. We all watched that video.
Oh, he's going to get mad now.
And we know that even before that, you appeared angry and upset. 2 individuals testified about you being at that mobile gas station, how you turned the wrong way down a one-way street, waved your hands in the air, rolled down your window, either exchanged gestures or words with one of the drivers. Perhaps 30 minutes or so before the start of the parade, maybe an hour or so before you drove down the parade route. But what's important is the signage. Even you, at one point, I believe when you were talking with Detective Carpenter, noted, it was my words, my assessment, it was clear something was going on. I think what you said was a lot of shit was blocked off. You'd driven past those signs on the staging area. The fact remains they were there, sir. And the fact remains is you told Detective Carpenter that. We then heard from the witnesses related to Ms. Patterson. We heard from Corey Runkle. We heard from Erica Patterson herself. My impression, based upon Erica Patterson's testimony, who, by the way, she showed grace and dignity facing you, a man who clearly has no regard for her as a mother of one of your children, as someone you had a domestic partnership with and a relationship with at one point.
That's not true.
We know, and I would say this goes to your character, what was shown through that altercation and going up the hill, following her, slapping her. You know, the rules don't matter to you, not the rules of the road, not the rules established by court orders, not the rules even of decorum and decency. And I'll get to this more fully when I talk about your character. And I know you went hard at Attorney Opper for her bringing these things up, but those are legitimate, lawful sentencing considerations. And when I get to that point, I'll tell you the case law that supports that. Your character, even your pending cases.
I don't need no case law.
Talking under his breath.
We know at the time of all of this, right, you were out on bond for 2 felony cases, one involving a handgun, one involving the same vehicle in Erica Patterson, and one involving ultimately intimidation of Ms. Patterson.
Here it comes.
We know that on November 20th, and she was very contrite about this, she told you where she was. She invited you out there. That you had contact with her on the 20th. There was some physical.
Contact with her on the 20th.
Mr. Brooks, this is my time. You
That's
need
the
to
reason.
not
That's
interrupt.
the reason why the charge was dropped.
Mr. Brooks,
The state
you need to
said
stop.
specifically, wrote you, Your Honor, and said that they know it was no incident that day.
Mr.
And now
Brooks,
you want to sit up here.
do not interrupt me
you-
or you will be removed to
And,
the other
and now you
courtroom.
want to sit up here
Stop.
and try to
now.
add something in that you know for a fact never even happened. You want to sit up here
Mr.
and talk
Brooks,
about
every
who has
time-
grace and all this. You talking about someone with 5 kids that don't have
You
custody.
need to stop
None of
right
them.
now or you will be removed.
Remove me then.
All right? He
Sure.
will be removed. He cannot simply stay
I don't
quiet
consent
when
to
this
being
court
in
talks.
this anyway. I don't consent to this, just like I told you. I don't know the
Be in recess until he's
I don't
removed
even
to the other
understand
courtroom.
the true nature in court.